Good afternoon. I'm Catherine Santoro, Director of Policy and Development at the National Institute for Healthcare Management Foundation, and I'm pleased to welcome you today to this webinar, King versus Burwell, Debating the Future of the ACA. With less than a month to go before oral arguments are heard by the Supreme Court, we're excited to be joined today by a distinguished group of speakers who have been writing and speaking on this important case that questions whether the Affordable Care Act authorizes subsidies in states not operating their own exchanges, and that many are speculating will determine the future of the ACA. Before we hear from them, I'd like to quickly thank NIHCM's President and CEO, Nancy Chalkley, who led the development of today's webinar, as well as the NIHCM staff who have helped convene the event today, Caitlin Ellis, Katie McDonald, Carolyn Myers, and Amanda Parker. You can find full biographical information for all of our speakers, along with an agenda, copies of slides, and additional resources on our website. We also encourage you to use the hashtag KingVBurwell to live tweet during the event this afternoon. I'm now pleased to introduce our speakers. Our moderator for this afternoon will be Julie Rovner, Senior Correspondent with Kaiser Health News. Julie's an expert on many health policy issues and has been reporting on this case and its potential impacts. Julie joined Kaiser Health News after 16 years as a health policy correspondent for NPR, and she'll be moderating what is sure to be a lively debate this afternoon between two of the leading experts on this case, Michael Cannon, Director of Health Policy Studies at the Cato Institute, and Nicholas Bagley, Assistant Professor of Law at the University of Michigan Law School. Michael has been called the man who could bring down Obamacare by Vox.com, and the plaintiffs in King v. Burwell have framed their case on the arguments first presented by Michael and his co-author, Jonathan Adler, in a 2012 paper. And in the opposite corner, Nicholas has been presenting the merits of the government's arguments, as well as the potential impact of a ruling for the plaintiffs on the ACA in journal articles and other debates. They've both filed friend of the court briefs outlining their support, and they've been debating this case in a variety of forums on Twitter and in their respective blogs, and we're so fortunate to have them with us today for a live debate. So thank you all for being with us, and I'm going to turn the floor over now to Julie Rovner.
Hi, good afternoon, and welcome to everybody out there. I think everyone knows by now that this is a Supreme Court case about four little words. No, not those words. The words established by the state. To back up a little bit, King v. Burwell, which the Supreme Court will hear almost exactly a month from today, is what's known as a statutory interpretation case. So it's not about deciding if the piece of law and issue is constitutional or not. It's about deciding whether the Obama administration is implementing it in the way that Congress intended. At issue specifically are the fate of health insurance subsidies that are currently being provided in every state, including the 36 states where the exchange is being run by the federal government, healthcare.gov. The court's being asked to decide whether language in the law makes the IRS regulations implementing those subsidies nationwide is permissible or not. If the court sides with the challengers, those subsidies would end for several million people, and the result would be, well, we'll get to that. We have two of the most ardent advocates for each side with us today, and we will get to them momentarily. But first, here's how we'll proceed. Michael and Nick will each lay out his case for 10 minutes. Then each will get 5 minutes of rebuttal. Unlike the Supreme Court justices, I will not interrupt after the first sentence. But when they're done, I will get to ask a couple of questions. Then we'll open it up to the audience. If you're participating by phone, we'll have a way for you to ask your questions. Those of you on computers can submit questions in the window at the bottom left hand of your screen. So without further ado, we will turn it over to Michael Cannon.
Thank you, Julie and Nick, and to our hosts at the NIHCM. King v. Burwell is actually a very simple case. Unfortunately, there have been a lot of arguments that have been offered by the federal government in defense of its position, and it takes a long time to respond to all of them. And there are also other dimensions of this case that merit some examination. But there's really so many layers to this onion that we can't possibly get to all of them in just 10 minutes. So I'm going to try to cover what is the most important stuff, and hopefully we'll get to some of the other layers of the onion in the question and answer period. The first layer is, what is the question that's before the Supreme Court? Well, if you look at the statute, it says in Section 1311, it directs states to establish exchanges. It says each state shall establish an exchange. Later in Section 1321, it details what the federal government is to do if a state fails to establish an exchange. In that case, HHS shall establish and operate such exchange within the state. Later still, in Section 1401 of the PPACA, Congress authorized subsidies. We call them tax credits. They're really cash payments to insurance companies in exchanges that were, quote, established by the state under Section 1311. That comes from the eligibility rules for those subsidies. It is the only part of the statute that speaks directly to the question presented in King v. Burwell, which is whether the Patient Protection and Affordable Care Act authorizes those subsidies through exchanges established by the federal government. Now, it's important to recognize that these subsidies are not, they're related to other parts of the law. What they do is the presence, the availability of those subsidies triggers penalties under both the individual mandate and the employer mandate. And as Julie mentioned, the IRS is implementing them in the 37 or so states, not just the subsidies, but the penalties as well in the 37 states where the federal government established the exchanges rather than the state establishing the exchange. So what is the impact of this been? Well, this graph shows the number of people in each federal exchange state who have been subjected to the individual or the employer mandate despite being statutorily exempt. In Texas, you'll see that there's more than 8, the blue bar shows that more than 8 million individuals and employers are being subjected to those mandates, even though they should not be because Texas did not establish its own exchange. The red bars show how many residents are receiving subsidies through the federal exchange in that state, even though the statute specifically precludes that possibility. And in Texas and Florida, it approaches 1 million people. But the important thing to note here is that while some people are benefiting from the administration offering those subsidies in federal exchange states, by far, most of the people affected by that decision are being adversely affected. They are being subjected to those mandates and those penalties from which they are statutorily exempt. So some of those plaintiffs have brought suit in 4 different lawsuits, and one of them is King v. Burwell, and it's going before the Supreme Court next month. And the question presented in that case is, did Congress authorize the IRS to issue premium subsidies in states with exchanges established by the federal government? And what's happened in these cases so far is we have 3 standing judicial opinions. The first one was handed down in July of 2012, not just the first that's still standing. There have been lower court decisions, but of the 3 that are still standing, the first one was handed down in July of 2014, and the D.C. Circuit said that, on the question presented, the D.C. Circuit said that no, the statute is clear and unambiguous. Those subsidies and penalties are authorized only in states that establish their own exchanges. The government's case is implausible, and those subsidies and penalties are therefore unlawful. A district court in Oklahoma, in Pruitt v. Burwell, I think it was in October of last year, reached the same conclusion. They said that no, the statute is clear and unambiguous, the government's case is implausible, and the disputed subsidies and penalties are unlawful and must stop. Only in one of these cases, King v. Burwell, did a court rule for the government. There, the Fourth Circuit said that the plaintiff's case is actually plausible, but the court found that the statute is ambiguous and deferred to the IRS's interpretation of the statute and found that those subsidies and penalties are lawful, or the IRS's interpretation is permissible. So why are these cases important? Well, as Julie sort of intimated, they would end, if the plaintiffs are successful, then the courts will strike down as invalid, as never authorized by Congress, the taxes and the subsidies that the Obama administration is implementing in those 37 states with federal exchanges. In total, 57 million individuals and employers would be freed from the employer and individual mandates under the PPACA, or the courts would find that they have always been exempt from those mandates. And about 4 million healthcare.gov enrollees would lose the subsidies they are currently receiving, because if the only way the plaintiffs win is if the courts say that the statute is clear and unambiguous that those people were never eligible for those subsidies in the first place. Now, a lot of people, I see that all of my bullets here are numbered number 1. A lot of attention has been paid to these 4 million healthcare.gov enrollees because they would take a serious hit. They would, if the Supreme Court decides that those subsidies are and always have been unlawful, then they would be on the hook to pay them back any subsidies that they had received. And they could therefore face a tax hike of up to $5,000 per person. When the subsidies disappear, the subsidies cover about 76% of the premium for people who receive them, and so those people would go from being billed for 24% of the cost of their coverage to paying 100% of the premium. So their bills the premiums could effectively quadruple. They could lose their health plans, and they might not be able to find a replacement. So a lot of these people these 4 million people are also victims of the IRS's attempt to rewrite the statute and issue subsidies it had no authority to issue, because these people have been made dependent on those subsidies, including about 1 million people. These are data from the Urban Institute and some other organizations. About 1 million of those who are enrolled in healthcare.gov did so because they were promised secure coverage and left jobs with more secure coverage to enroll in healthcare.gov, really because of the promise of these subsidies that whose legal basis is non-existent. So these are, I think, among the victims of the IRS's behavior here. I think these are the folks who are going to be the hardest hit. The folks who lose subsidies and were lured out of more secure coverage in order to enroll in healthcare.gov. So that's sort of the first layer of the onion. What is the question presented, and what are the stakes here? A lot of people have argued, the government has argued, that it was always Congress's intent to issue those subsidies through federal exchanges. So I want to walk through some of the reasons why that's not the case. A lot of people think it's implausible that Congress would have withheld health insurance subsidies from non-compliant states, from states that refuse to cooperate with the implementation of the PPACA. But that's what President Johnson and Congress and President Johnson did when they created the Medicaid program back in 1965. It has always operated on that basis. If states don't cooperate, the residents get no subsidies. President Nixon, when he introduced his health care reform proposal in 1974, threatened to withhold federal funds from states that did not help to implement that plan. President Bill Clinton did the same thing in 1993. If a state did not help to implement his Health Security Act, then the Secretary of Health and Human Services would reduce federal payments to those states. President Clinton and Congress created the State Children's Health Insurance Program in 1997. It operates on the same basis as Medicaid. States that don't cooperate deprive their citizens of federal subsidies for health insurance, children. The lead author of the PPACA was Senate Finance Committee Chairman Max Baucus. In 2002, he proposed and Congress enacted a tax credit for health insurance for certain individuals who would only become eligible for those tax credits if their states took action to make them available. If their states did not cooperate, they didn't get the tax credit. In 2008, Senator Baucus proposed a small business tax credit that would be available only in states that established that implemented price controls on health insurance in that state, what he called patient-friendly insurance.
Start wrapping up.
And in 2009, one Senate committee, and every Democrat on the Senate Health, Education, Labor, and Pensions Committee supported a bill that even the government concedes would have withheld exchange subsidies in states that did not implement that bill's provision. So this is the sort of thing that Congress does all the time. They did it in the PPACA's Medicaid expansion, as we all know. Some members of Congress complained that that's what the PPACA did, that if states didn't implement exchanges, their residents would not see any benefit. Our own moderator, Julie Rovner, reported on those concerns that House Democrats expressed with the PPACA that if the states didn't bother to create an exchange, their residents would have no way to benefit from the new law. So, and of course, there's Jonathan Gruber who said exactly that in 2012 before this became a big issue and they realized it was a potential liability. The most important takeaway, or the most important thing to understand, is that all of this is actually irrelevant if you want to know what Congress's intent was. Because if you have clear statutory language, which is what we have in the PPACA, then that is congressional intent, particularly in a case like this where Congress had a choice between one bill, the PPACA, or nothing at all. Because if the language is clear and that's their only choice and they vote for it, well, then they're signaling that that is their intent. And as a White House advisor put it in March of 2010, this was the last helicopter out of Saigon. So they, whatever they voted for in this law is what they intended. So, Julie, do I have any time left?
No, you're 2 minutes over. But
Okay.
you can get to this in the rebuttal.
Okay, I wanted to get to the government's case, and Nick will lay that out, and we'll have a lot to say about that. As I mentioned, there are many layers to this onion.
Okay, great. Nick?
Hi, thanks to Michael for agreeing to go head-to-head with me, and thanks to Julie for hosting this. I'm very happy to be here, and I'd like to start by clearing something up right away. When the federal government sets up an exchange on a state's behalf, it doesn't create some sort of federal exchange. It creates a state exchange, and the statutory language is crisp on this point. Recall that Section 1311 of the Act instructs states to set up their own exchanges, to establish their own exchanges. Under Section 1321 of the Act, when a state fails to set up the required exchange, which is to say a state exchange under 1311, the Secretary of HHS must establish and operate such exchange within the state. In other words, the backup exchange in the Affordable Care Act isn't a federal exchange. It is a state exchange. And it is established under 1311 just like the provision authorizing tax credits requires. I don't take Michael to contest that basic point. And so understood, the Secretary just stands in the shoes of state officials when she sets up their state's exchanges. And any exchange she establishes is the legal and functional equivalent of a state exchange. Now Michael says, no, that's not so. According to Michael, Congress used three little words inserted in the provision for the calculating the amount of the tax credit, the words by the state, to signal that tax credits would be unavailable on federally established exchanges. Now that argument, if accepted, would have extraordinarily serious consequences. About 9.5 million people in the 34 states that declined to establish their own exchanges are eligible for tax credits. In 2014, those tax credits were worth about $2,890 per person on average. So Michael is asking the Supreme Court to impose a massive tax hike on the American public. Now the trouble with Michael's argument is not because it conflicts with some namby-pamby idea of what Congress may have wanted. The trouble with Michael's argument is that the statutory text doesn't support it. The Supreme Court has been abundantly clear time and again that you can't read statutory phrases like established by the state under 1311 in isolation. Sometimes reference to the broader context of a statute confirms that a snippet doesn't mean what it might at first appear to mean. And this, I should say, is not a controversial point. It's one that both textualists and purposivists, both conservatives and liberals, embrace. All interpreters seek to ascertain the meaning of statutory language by looking at the whole statute, by trying to figure out what Congress meant. And if you read the Affordable Care Act as a whole, it's apparent that Congress never meant those three words to bear the immense weight that Michael would assign to them. It's not only that Congress instructed the Secretary to set up a state exchange, which reinforces the suggestion that she just steps into the shoes of state officials. In several places in the Affordable Care Act, Congress clearly used similar, quote, exchange established by the state language to refer generally to exchanges, including federally established exchanges. And if that's so elsewhere in the statute, why not in the provision governing the calculation of tax credits? First and foremost, the ACA allows only, quote, qualified individuals to buy health plans on the exchanges. But a qualified individual is defined as someone who resides in the state that established the exchange. Well, does that mean that no one can purchase a health plan in those states that have declined to establish their own exchanges? The federally created exchanges, healthcare.gov, would have no customers, would have no purpose, and that can't be what Congress meant. But that's what the reading the statute as Michael would read it would accomplish. The more natural inference is that an exchange established by the Secretary should be treated as the statutory equivalent of a state-established exchange. Second, take the statutory provision that explicitly requires every state to maintain their Medicaid eligibility standards until, quote, an exchange established by the state is up and running. This maintenance of effort provision was meant to provide stopgap protection for Medicaid beneficiaries until the exchanges went live. As Michael would have it, though, this provision would actually forbid states that declined to establish exchanges from ever relaxing their Medicaid standards. And there is zero evidence that Congress meant the ACA to freeze state Medicaid programs into perpetuity. Third, finally, take the statutory provision that explicitly requires every exchange. And here, this provision of the statute is quite clear that it refers to exchanges established either by the Secretary or by the state, to provide information to the IRS about, quote, the aggregate amount of advanced tax credits that each individual receives when they purchase a plan on healthcare.gov and the state exchanges. The point of this provision, and the very title of this section makes it clear, is to allow for the, quote, reconciliation of credits and advanced tax credits. Why on earth would Congress insist that federally established exchanges share information about tax credits when not a soul buying health plans on those exchanges, on Michael's theory, could ever get them? The provision would be so much surplusage. It would be so much unnecessary language. Michael, however, brushes past all these statutory signals, and he insists that this phrase, established by the state, appears in any number of places in the Act, and that it must have served some kind of purpose. And in his view, Congress withheld tax credits from states that declined to create their own exchanges in order to goad them into establishing exchanges. Congress was making a threat on this view. Set up your exchanges or you'll lose out on tax credits. This is a completely implausible reading of the statute. And here's why. A threat isn't a threat unless it's clearly communicated. When Vito Corleone made the proverbial offer that can't be refused, he didn't just say, sign the contract. He had Luca Brasi hold a gun to the head of the guy and assured him that either his brains or his signature would be on that contract. Without the gun, there is no threat. Here, however, the supposed threat was so well hidden that the states didn't even notice it. No gun, no threat. And no wonder the states didn't notice it. The phrase established by the state under 1311 isn't exactly easy to spot. It's awkwardly crammed in subsection B2A in a section of subpart C of Part 4 of Subchapter A of Chapter 1 of the Internal Revenue Code. And it's outlandish to think that Congress inserted the innocuous words by the state into the complex calculation of the tax credit in order to issue a threat of this magnitude to the states. After all, Congress knows how to threaten states with financial consequences when it wants to. No one shows that better than Michael when he runs through other statutes that have imposed financial consequences on the states. And they do so clearly and unambiguously in provisions that are directed at the states. The absence of any such clear language in the Affordable Care Act is powerful evidence that Congress never meant the availability of tax credits to turn on whether a state happened to establish an exchange. And the notion that Congress meant to threaten the states is doubly implausible because the backup exchanges, healthcare.gov, on his theory, will not work. Without tax credits on federally established exchanges, as Michael acknowledges, many healthy people are going to forgo coverage. Those with serious health problems, however, they're going to remain in the market because they've got high medical costs. The risk pools for exchange plans would become skewed toward sicker enrollees, and that in turn is going to increase the cost of insurance plans in the state. As costs go up, healthy people would decline insurance, leading to sicker risk pools, higher prices. We'd get the adverse selection death spiral with which we're all familiar. In other words, the exchanges, these backup exchanges that Congress carefully crafted, would simply stop working. This isn't just me talking. The Rand Institute concluded that if the tax credits are invalidated, what you're going to see is a near-death spiral on these exchanges. Why construe the Affordable Care Act to create dysfunctional backup exchanges when a plausible alternative reading would avoid that result? And the context in which the ACA was adopted just reinforces the point that there never was and is not any such threat. Look, the debate over the Affordable Care Act didn't exactly pass unnoticed. I was there, you were there, Julie was reporting on it. No one during that debate, no one ever said that the statute that Congress enacted was meant to strip individuals on federally established exchanges of subsidies. Not one person. In any event, here's the bottom line. Even if you don't agree with me about the best reading of the statute, even if you're sort of attracted by Michael's interpretation, surely reasonable minds can differ about whether the statute requires the withholding of tax credits in states with federally established exchanges. Which is to say, the statute is at least ambiguous on this precise point. And under Supreme Court case law that's been settled for decades, when there's ambiguity in a statute, it's the agency that implements the statute that is charged with resolving that ambiguity. And here, the IRS has construed the ambiguity to make tax credits available on federally established exchanges. That's a perfectly reasonable construction of the statute, and it's one that the courts, including the Supreme Court, owe deference to.
Nick,
all of which is to say that the outcome of this case shouldn't matter. It shouldn't turn on whether you're a textualist or a purposivist, a Republican or a Democrat, a law professor or a member of the Cato Institute. For even the strictest of textualists, statutory context can help make sense of statutory meaning. And here, that context all points in one direction, that tax credits are and were meant to be available in states with federally established exchanges. Thanks.
Thank you. We're going to go back to both Michael and Nick for 5 minutes of rebuttal. So Michael, do you want to start? And can I ask you guys to please remember to mute your phone when the other person is talking?
Okay, thank you, Julie. So I had a slide set up for this. If we can go back to it, I'd like to, but if not, that's fine. Basically, the government and Nick are in a really difficult position here because everyone recognizes that the operative language of the statute, the only language in its statute that speaks directly to the question presented, which is the subsidy eligibility rules in a PPACA, directly undercuts the government's and Nick's position. It says the opposite of what they claim the statute says. It says those tax credits are available only, quote, through an exchange established by the state. And everyone knows what that means. Supporters of the government's position here admitted that the language there is plain before they realized that how weak their case was and that they couldn't admit that. The IRS, when it was drafting its regulations implementing this part of the statute, initially had that statutory requirement for tax credit eligibility in their regulations. They took out that requirement that recipients enroll through an exchange established by the state. They dropped that language because they recognized that poses an obstacle to what they wanted to do, which was offer tax credits through federal exchanges as well. If what the government and Nick are saying right now is true, if it is that language does not pose an obstacle to tax credits in federal exchanges, there would have been no reason to take that out of the draft regulations, but they did. Moreover, it's not the case, as Nick claims, that an exchange established by the federal government is an exchange established by the state or is a state, and the government recognized this when it issued the proposed regulation in August of 2011. It did not say that an exchange established by the federal government is a state-established exchange, or that an exchange established under Section 1321 is a 1311 exchange. It distinguished between the two. It said that you get a tax credit under an exchange established under Section 1311 or 1321, recognizing that they're distinct as the statute recognizes that they are distinct. So when Nick, now the government's got a really uphill climb here, because the plain meaning of the statute contradicts their position, and everyone knows it. So what do? Well, they make two arguments, and you heard them both from Nick. The first one is, no, the plain language of the statute supports our position and authorizes tax credits through a federal exchange. And the way that the government makes that case, Nick didn't make it here, although he's made a similar argument before, is the government says in its brief before the Supreme Court that the phrase through an exchange established by the state is simply a term of art that refers to an exchange established either by the state or the federal government. Now, that doesn't even pass the giggle test. I should say that Congress, if it wanted to, could have defined the phrase through an exchange established by the state to mean through an exchange established by the state or the federal government. It could have defined that phrase to mean through a bologna sandwich if it wanted to, but because Congress is not bound by the ordinary meaning of words. But the executive branch is bound by the ordinary meaning of words, and it doesn't get to decide that that phrase is somehow a term of art that means something other than its ordinary meaning, just because the government thinks the statute would work better that way. But that's what the government did here. It took that phrase and said, you know what, we think it would work better if that phrase actually meant through a bologna sandwich, and they implemented their creative reinterpretation of the statute instead of the words that Congress actually said. But the government doesn't, and Nick don't actually expect you to believe this because it's nonsense. What they're hoping to do is throw enough provisions of the statute which do not speak to the question presented and which aren't actually, don't even conflict with the operative language in the statute, throw as many of them out there and try to give them interpretations that would conflict with the statute, would conflict with the operative language of the statute, so that they can get to their main argument, which is that the statute is ambiguous because executive branch agencies get a lot of deference from the courts when a statute is ambiguous and the agency's interpretation of that statute is reasonable, or interpretation of the ambiguity, resolution of the ambiguity is reasonable in the court's eyes. The problem here is that the statute is not ambiguous. None of those provisions conflict with the plain meaning of the tax credit eligibility rules. Nick gives a long list of provisions that to which he assigns those odd interpretations, hoping to create the appearance of ambiguity. But we could go through each one of them, and none of them conflict in any way with the language restricting tax credits to state-established exchanges. And he also, and Nick's claims about congressional intent are also off base. And all you have to do is look at other legislation that Congress is considering at the same time. As I mentioned, the bill that was approved by the Senate Health, Education, Labor, and Pensions Committee, more than a dozen of the same Senate Democrats who voted for, were crucial in voting for and crafted the PPACA, they voted for a bill that would have done all these things that Nick thinks is unthinkable and that Congress would never do, withholding tax credits, withholding exchange subsidies in that bill's exchange. Congress also voted for, in the PPACA, the CLASS Act, a long-term care entitlement program, over the objections of Medicare's chief actuary, which said that that program would lead to a death spiral because it had the same provisions as the exchange parts of the PPACA, but it didn't have a mandate and it didn't have subsidies. In fact, it too had an explicit ban on subsidies in the CLASS Act, but Congress enacted it anyway. So Nick's claims that Congress would never do this just don't work. And for other reasons, even if the statute were ambiguous, the IRS's interpretation would not be entitled to deference from the courts, and we can get into the reasons for that.
Okay, thank you. Nick?
Hi, I just have a few points in rebuttal. So look, read in isolation, Michael's interpretation of the established by the state language kind of holds together. It does arguably signal Congress's intent to key tax credits to state-established exchanges. But you never look at a statute, you never read a provision of a statute in isolation. And I want you to think for a moment of just how much violence Michael's interpretation of the statute would do to the text of the statute. There would be, on his view, no qualified persons in any of the 34 states that refuse to establish their exchanges, suggesting that healthcare.gov would have no customers and no purpose. Federal exchanges would be reporting tax credit information for no good reason. Eligibility standards for Medicaid would be frozen into perpetuity. On the off chance that they were allowed to sell exchange plans in the first place, the fallback exchanges that Congress established and that Congress so carefully planned for would be completely dysfunctional. And hostile states could thwart the ACA's obvious and apparent effort to extend near universal insurance coverage across the whole country. In other words, Michael's interpretation would wreak havoc with the statute as a whole, much more so than the government's proposed construction, which, yes, says, look, read in context, the phrase established by the state under 1311 is best understood as a term of art to refer to exchanges, however and whoever established them. And if the goal of the interpreter, as it is to make the best sense of Congress's work product, it makes total sense to try to construe it as a holistic, as a whole. It doesn't make sense to read this snippet of the text in isolation. A couple of more direct points. Michael says that the only provision that speaks to the question in this case is located in the established by the state tax credit provision. That's just false. There is, in fact, a section of the Act that points out the consequences to the states if they decline to establish exchanges. It's Section 1321 of the Act, and it details what happens when a state fails to set up an exchange. Nowhere in that provision, which is directed at the states, is there any mention of the tax credits. That's where you'd expect to see it, if in fact Congress meant to level a threat of this magnitude at the states. And that's why we have judicial doctrines that require Congress to speak clearly when it intends to put consequences on states for their choices. Congress has to speak clearly, or we're not going to read statutes to do violence to the federal scheme. I want to close by sort of pivoting off the legal arguments for a minute and just talk about the consequences very briefly for what would happen if the IRS rule were invalidated. So the 34 states that declined to establish their own exchanges probably wouldn't be able to stave off the immediate destabilization of their insurance markets. The court is likely to release its opinion in late June, and its decision would take effect very shortly thereafter, which would wipe out tax credits to the then about 7 million people who are getting tax credits on the exchanges. In all likelihood, those people would be asked to pay full freight for their insurance coverage. Most of them can't afford that, so enrollees who are unwilling or able to pay full freight will drop coverage. Those enrollees will see their coverage terminated, perhaps as soon as 30 days after they fail to make a payment. So by late summer, we're going to see enough of those people shed coverage that insurers are going to face extraordinary losses because they're only getting premiums from very sick people. Most insurers are going to refuse to participate in the exchanges in 2016. Those that remain are going to have to double or triple their premiums. Now, the 7 million people who lose out on their tax credits at the state level are going to scream bloody murder, and they're going to put a lot of pressure on their states to establish exchanges. But it's much too optimistic to think that as a group, the states will just snap their fingers and establish exchanges. For one thing, setting up an exchange is not child's play. It's not easy. By statute, exchanges have to be nonprofits or state agencies. They've got to be capable of discharging any number of obligations, including running a navigator program, approving insurers, managing enrollment. Setting up an exchange requires a considerable investment of time and resources. And for another thing, the states need legal authority to establish exchanges. And in many of those states, including 7 that have forbidden their governors from setting up exchanges in connection with the ACA, legislatures would have to pass laws enabling the creation of exchanges. But only 8 of the 34 states that refuse to set up their own exchanges even have legislative sessions after June when the Supreme Court is expected to rule, meaning that they'll have to call special sessions in order to get exchanges up and running. And that assumes that those states even want to establish their own exchanges. And that's by no means a given, especially after the 2014 elections. Nor is a dysfunctional Congress riven by partisan bickering very likely to get its act together in the heat of a presidential primary to implement any kind of surgical fix to the Affordable Care Act.
In all likelihood,
yeah, sure. In all likelihood, then, I think what we're going to see is a very large number of states, probably the vast majority of those that have failed to set up their exchanges, lose out on tax credits in 2016 and perhaps beyond. And to what end? Congress is very unlikely to overturn the ACA rules that prohibit insurance companies from discriminating against those with pre-existing conditions. So what are we going to have? We're going to have a bunch of basket case insurance markets, stubbornly high rates of uninsurance, millions of unnecessary bankruptcies. And even if you don't like the ACA, it's really hard to see how that's a desirable outcome. Thanks.
Okay, thank you both very much. We're going to move into the Q&A with the Q&A from me first, and then we will open it to the audience. Before we get to that, since though I'm going to sort of step out of my moderator's shoe just for a moment, since Michael was very kind to find that lovely picture of me and quote my story, I would point out that if people want more of the context of the story, it is available on the web, but I will also tell you that while that Texas letter did express concern about people not getting any benefits, they weren't talking about subsidies. And in fact, the paragraph immediately prior to that reads, this is talking to Tim Jones, this was about the House versus the Senate version of the exchanges, not so much whether subsidies would be available. But Ken Joe said, it seems to be a much more complicated process that has more room for failure and frankly, I think a lot less accountability, he says, because if the state fails to do it, then the federal government is supposed to step in. But I think it's going to be difficult for the federal government to step in to say to a state, you failed, we're taking over. So that's actually the context in which I mentioned the Texas letter.
And I presume I will get a chance to respond since you're taking Nick's side.
I will. And you go ahead and respond.
Well, there's no other plausible reading of that letter or of your story, because the letter itself acknowledged that the federal government would step in and create an exchange in states that did not, and it categorically ruled out any benefit for residents of states that did not establish exchanges, even if the federal government stepped in. And this is exactly who you would expect to notice and complain about that provision of the PPACA. A very left-leaning member of Congress, Lloyd Doggett, in a very right-leaning state, Texas, the type of state that was least likely to implement a health insurance exchange. So you've denied that that's what the letter and your reporting of it means. Nick has taken issue with what that letter and what that letter means, but there's just no other interpretation of it. The letter categorically rules out the possibility of residents of non-cooperating states receiving any benefit from the PPACA's exchanges.
I'll chime in on the letter. So I encourage anyone listening to go back and read the letter. What's startling about the letter is that although the Texas Democrats expressed concern that Texas might impede the Affordable Care Act if Texas was given a lead role in potentially implementing it, what's striking about the letter is that there is not one word said about tax credits. Not one. They talk about impeding progress in the state, and in fact, Texas has done all sorts of things to impede the rollout of the Affordable Care Act, including declining to enforce its insurance provisions. But the absence of any mention of the loss of tax credits is the dog that didn't bark in the night. If Doggett really meant to raise concerns about tax credits, surely he would have mentioned it. Again, I encourage you to read the letter. It simply doesn't bear the interpretation that Michael would assign to it. And look, I respect the view that the statute says what the statute says, but the notion that this is what Congress actually meant to accomplish, the notion that there were people who harbored this subjective intent at the time, it is fiction. It is a fabrication. There's just nothing to support it.
All right, I know, Michael, you want to respond, but we're going to need to get to at least a couple of questions, and then you can maybe take this up in this next question. Let's back up a little bit and talk about what previous cases involving statutory interpretation that the court might take into account in deciding this particular case. So, Michael, you want to start?
Well, there are a couple of cases last term, UARG and Bay Mills, where the court looked at plain statutory terms and said, look, it doesn't matter if it doesn't seem to make sense, or the administrative agency thinks that the statute would work better if the terms were interpreted a different way, or if it rewrote the agency rewrote the statute. The court said that when the language of the statute is clear, then the agency has to follow that language, even if it doesn't like the result, because Congress is the one that gets to write the language, and if there are problems, it's up to Congress to fix it, not the administrative agency and not the courts. And they were dealing with very plain terms, like we find in King v. Burwell, and it wasn't just the Republican appointees or the conservatives or the strict textualists on the court that were reaching this conclusion. Elena Kagan, I think it was in Bay Mills, made that very point, that look, even if you don't like the way the statute works, even if it seems counterintuitive to you, as long as it's not absurd, and the government in King v. Burwell does not argue that the language is absurd, as long as it's not absurd, then the agency has to follow the plain meaning of the statute. And on Nick's point that there's no evidence that members of Congress wanted to do this, it's just not true. The legislative history here is very thin, but all of the legislative history supports the text, points to the conclusion that this is an idea that was on Congress's mind. And Nick has no good response to the Health, Education, Labor, and Pensions Committee bill, which did almost the exact same thing. It withheld exchange subsidies in states that did not implement that bill's employer mandate. So all the parade of horribles that Nick thinks that Congress would never allow to happen, because Congress so carefully crafted this last helicopter out of Saigon, the Health Committee Democrats were perfectly willing to accept, because that's what they voted on, that's what they put into their bill. If the state didn't implement the employer mandate under the health bill, then there would be no subsidies, you would get the adverse selection death spiral, states that oppose the bill would be able to bring it down. All these things that Nick says that Congress should never do. More than a dozen members, Democratic members of the Senate, are on the record as supporting exactly that, and the government concedes that that's what they supported. Where there's no evidence, the side that has no evidence to support their interpretation of the statute is the government. Because even though as far as I know, I've done more research on the legislative history of this case than anyone else has. And I have found absolutely nothing that indicates that any member of Congress intended for the PPACA to authorize tax credits in federal exchanges. Now, I don't have access to the servers at the Senate Finance Committee where this language was drafted, or the Legislative Counsel's office in the Senate that put the language together with Finance Committee staff, or Senate now Minority Leader Harry Reid's servers, or the House Democratic leadership servers, where they would have information, where there might be additional legislative history that discusses what the Senate staffers and members were thinking about when they crafted this language, and how the House Democrats responded to it when they had to swallow hard, and vote for the PPACA. There could be additional legislative history there that speaks directly to this question, but we know two things about all of that additional legislative history. One, they have not granted anyone access to it. In other words, there's a lot of potential information there that one side of this case controls, and they will not release to the public. And two, they have not released anything to the public that indicates what Nick says, that indicates what the government says, that indicates that there was a single member of Congress that expected this statute to authorize tax credits in federal exchanges. There is absolutely nothing there.
Nick, you can respond, but also will you go back and talk about some of the Supreme Court precedents that govern statutory interpretation?
Sure. Back in 2000, the Supreme Court had to consider a case involving an FDA assertion of regulatory authority over nicotine, over tobacco. And FDA said, look, we've got a statute that allows us to regulate drugs. Within the statutory definition, nicotine is a drug. There was no doubt that as a textual matter, that was true. And therefore, the FDA said they had the authority to regulate cigarettes like a drug. And the Supreme Court, in a 5-4 decision with the 5 conservative justices voting in the majority, voted to strike down the FDA rule on the ground that, sure, read in isolation, this statutory provision would seem to give FDA authority to regulate cigarettes. But the court said, if you read the statute as a whole, And in light of sort of what we know about how Congress operates, there's no way Congress meant by those words to authorize FDA to assert jurisdiction over tobacco. That kind of contextual interpretation of the Act is exactly what the government is pressing here. And it's not controversial, right? Michael is absolutely correct that the courts don't have, that the IRS doesn't have the authority to rewrite statutes. Nobody contests that. The question is what the statute means. But statutes are not self-interpreting. Statutes have to be interpreted. They've got to be made sense of in context. And here the best reading of the statute as a whole is that tax credits are available in states with federally established exchanges. But again, even if you don't agree with me, the most important case you need to keep in mind is a case called Chevron, a case that says that where a statute is ambiguous on the question before the court, it is up to the agency that administers the statute to resolve that ambiguity. And here, at a minimum, the statutory text is ambiguous. On the questions about the legislative history here, one question you should ask yourself is, you know, if this were Congress's intent to issue a threat of this kind of magnitude to the states, surely we'd see some evidence of it. But no legislator during the debates ever said it. No journalist covering the debates ever said it. Nobody ever specified that tax credits wouldn't be available if you went to a federal backup exchange. No other federal scheme looks like this, not only where you kick the states that fail to participate in the federal scheme, not only sort of encourage them with money, but then put a torch to their individual insurance markets. It's just not the way that Congress operates. And if Congress were to operate like this, and surely it could if it wanted to, you'd know it. You'd know it because there's a clear spot in the statute where Congress would have made that threat clear, which is in the provision about what the consequences were if the states failed to establish exchanges. But those provisions of the statute are silent on this. And the notion that Congress issued a threat like this, but did so quietly and surreptitiously, is fanciful. It just doesn't hold up to any kind of close scrutiny. And Michael says, I've got no answer to the HELP bill. Of course I have an answer. Michael points to a bill where the consequences for a state's failure to play ball were clear. And he says, aha, Congress can do this. Well, of course Congress can. But the Affordable Care Act is a very different statute that does not look like that statute. And if it were drafted like the HELP bill, it would have looked quite different. So it's not that, look, Michael's claimed that if you just looked in the files and if you had access, this sounds like a conspiracy theory to me. And frankly, this is bad history. Again, I respect the view that Congress said what Congress said. If that's your position and you think the statute's clear, I understand that. But the notion that this is what Congress meant is a fable.
All right, well, let's move on to what might happen going forward. We know, obviously, that there are at least 4 Supreme Court justices who wanted to take the case early, basically, but before there was technically a split in the circuits. Who do you think, each of you think, is going to be the swing vote here, and why? Nick, let's start with you, so let Michael get last word.
I think it's very difficult to get into the heads of the Supreme Court justices. It's always possible that they'll all go, rule in favor of the government. But I think the reasonable money, given the 4 votes that agreed to hear the case early, is that there are at least 4 votes that are 4 justices who are skeptical about the Fourth Circuit's decision here. The 5th vote is anybody's guess. I think the dominant view is that the Chief Justice may be the vote that the government needs to get in order to prevail here. Possibly Justice Kennedy, but that the 3 most conservative justices are less likely to rule in the government's favor here. Whether that's true or not, it's always really difficult to anticipate, but I think people are looking to the Chief again, and we'll see. We'll have to see what he thinks.
Michael?
Well, I'm not sure that it's the case that the Supreme Court took this case early, because there was a circuit split, and there was still technically a circuit split, because the D.C. Circuit's rules say that even if the full D.C. Circuit agrees to hear a case en banc, review a panel ruling en banc, which is what happened in Hallbig v. Burwell, that vacates the ruling but not the opinion. So technically there was still a difference of opinion between the D.C. Circuit and the Fourth Circuit. And it was also, I think, not premature for the Supreme Court to take the case because of the tremendous dislocation that we are currently experiencing, where with every passing day, the IRS, as two of the three standing opinions in these cases have held, is spending billions of dollars illegally and penalizing millions of Americans without congressional authorization. That creates a certain sense of urgency. And so a quicker resolution of this case, I think, argued for the Supreme Court taking it up. In fact, the first of these cases was filed by the Attorney General of Oklahoma in September 2012, which speaks to the point that Nick made, that states didn't notice this provision of the law. In fact, two states filed two of the challenges to this very reinterpretation of the law. But your question was about where the justice is going to go, and I think Nick's right. If the fact that the Supreme Court granted cert in this case means that at least 4 justices are very skeptical of the one standing judicial opinion that went for the government. That was from the Fourth Circuit. The Fourth Circuit acknowledged that the plaintiffs had a decent case, but they found that the government's argument was only slightly better, and then decided to defer to the IRS based on the doctrine of Chevron deference. Most people who follow this case say that it's that the questionable, as Nick mentioned, the justices with the question marks over their heads are going to be John Roberts and Anthony Kennedy. But again, you know, I don't know how to read the justices' minds. I do think, though, that if they follow the existing precedent, this is a very simple case. The language is clear, and even if the government doesn't like the statute, or people who support the law or say they support the law, their concept of the law, don't like what the statute says, well, then Congress can fix it. The reason the Obama administration changed the statute and departed from the plain meaning is because they knew that Congress would not fix it according to their liking, and so they thought they could do it themselves. But if the Supreme Court follows existing precedent, they will kick that decision back to Congress and say it's not for the administration to make this change, only Congress can.
I'm so glad you ended with that, because that is my next question. Assuming that the Supreme Court rules with King, rules for the challengers, and invalidates the subsidies, what would you expect to happen in Congress? I mean, one of the things we've heard recently is that having to put these subsidies back would subject them to a score of something like $340 billion over the next 10 years. So, Michael, why don't you go first on this one?
Well, it's going to be very difficult. Republicans in Congress have signaled two things already. One, that they will have a plan or a response if the court rules for the plaintiffs. And two, that it will not be simply to reinstate those subsidies. I don't say reauthorize those subsidies, because the only way the plaintiffs win is if the Supreme Court finds that those subsidies were never authorized in the first place. If you want to know why Congress isn't going to do that, why Republicans in Congress aren't going to do that, you have to remember what all the effects of a ruling for the plaintiffs would be. Subsidies, the illegal subsidies would disappear, but so would all those illegal penalties against those millions of employers and individuals. When those subsidies and penalties disappear, federal spending goes down, federal revenues go down, but the spending goes down by more than the revenues, so the deficit goes down as well. So if Congress were to reinstate those subsidies, were finally to authorize those subsidies, then you would have Republicans in Congress who would be voting to expand Obamacare. So right off the bat, they're not going to be eager to do that. Expand Obamacare from what the Supreme Court said, this is the law, this is what Obamacare is. They would have to add onto Obamacare. They would be increasing federal spending, increasing federal taxes, but not increasing federal taxes by as much as they increase federal spending, so they'd be increasing the federal deficit. The way that Republicans would be increasing federal taxes would be by imposing the individual employer mandates on 2/3 of the country. These are the parts of the law of Obamacare that Republicans hate the most. And Republicans would realize that they would, in fact, be ratifying illegal taxes and subsidies that the president tried to impose on his own. And that would be a terrible precedent to set that just upturns our entire constitutional order. So Republicans are not likely to do that. What they are likely to do is try to find some way to provide assistance to the victims of the administration's actions here. They're probably not going to impose the individual employer mandates on those who've been unlawfully subjected to them. They will try to do something for those people in the exchanges, particularly those who are lured out of more secure coverage for this very insecure coverage that is available on healthcare.gov, and it probably put some sort of free market reforms in there, try to loosen up or even repeal some of the regulations in the PPACA. But the president's not going to want to repeal a single jot or tittle of this statute unless he gets to do it himself without Congress, that is. So it's hard to see, it's hard to predict exactly how that process will play out.
Nick?
Yeah, I'm not sure it's so hard to predict. Look, the politics here will be volatile. You know, Michael's discussion of the employer mandate and the individual mandate to one side. The sort of outpouring of frustration from people who lose out on quite substantial tax credits, especially for those people who've made life choices, as Michael pointed out, like quitting their jobs so they can go onto the exchanges. The outcry is going to be intense, and Congress is going to come under intense pressure. I think Michael's right. The Republicans are unlikely to embrace a surgical fix that would increase spending relative to what the Supreme Court had held the ACA already did. So the Republicans are going to ask for something more comprehensive. And there are sort of two questions here. First, how far is the White House going to be willing to bend in order to get the tax credits back? And the White House might be willing to bend to some extent, but I think the White House might reasonably say, look, there are a bunch of states with the Affordable Care Act in place. More of them over time will establish their own exchanges. We're not willing to give up all that much in order to cut a deal. And the Republicans, for their part, have an even, they're going to ask for stuff that I think the White House is unlikely to give them. But more importantly, it's not at all clear to me that the Republican Party can come together with a comprehensive solution, comprehensive response to Obamacare. The Republicans have had a very difficult time coalescing around a single policy option for a good reason. Healthcare reform is really hard. You've got to make tough trade-offs. Some people are going to be winners and some people are going to be losers. And you can't promise everything to everybody, especially when there's a big CBO score coming down the pike. And I don't believe that the Republican, during a primary year, when we're going to be doing the presidential election, is likely to put together a proposal that is both comprehensive, and that is calculated to get the White House's support. So I think the likelihood we're going to get legislation to fix this is, with the caveat that you never know, I think vanishingly, you hear people say Congress is going to come forward with a solution, you should realize, you should take it for what actually posturing for the purposes of the Supreme Court decision, because Republicans want to claim that this would be a deal if the tax credits were invalidated, because they want to give the court comfort such a decision wouldn't have wrenching consequences. And I think that is much too optimistic.
Here's a question that someone has written in, and then we're going to go to the phone in a minute. They want to know, is this not some case that the administration can waive its executive order wand to fix? Is there some way that the administration could do this itself? Nick, why don't you start?
Fix, assuming the Supreme Court invalidates the tax?
Yes.
Yeah, I think that there would be serious obstacles to doing so. There are limits, as Michael rightly says, to what the executive branch can do when it comes to implementing a law, and they've got to color within the statutory lines. And the statute, if the government loses this case, will enable tax credits on state-established exchanges, but not the backup exchanges that the federal government establishes. Now, might there be some wiggle room on the margins? Sure. For example, we're pretty confident that the Treasury Department can assure that the tax credits would not be clawed back from people who have, up to that point, improperly received them. So you don't have to actually pay back to the government any tax credits that you received, even if the Supreme Court says they should never have issued. So that's one kind of executive action that the Treasury Department could take. The HHS could probably make it easier in some ways for states to hold up their hands and establish exchanges. But the states are still going to have to do something to say, yes, we would like to establish an exchange. And right now, the state-level politics, the state-level timing, the practical challenges are intense. So I think the notion that any kind of administrative fix is going to be a silver bullet here is just wrong. And again, another reason to be quite worried about the potential real-world consequences of an adverse Supreme Court decision here.
Michael?
So the question is, could the administration come up with a fix to this? The answer is not within the law. I mean, you have to understand, this is the fix that is being challenged. They're trying to skirt a requirement, a clear requirement in federal law, and if this fix doesn't work, then they don't have one that they can fall back on, unless they try again to rewrite the law in some way, and then that'll be subject to another challenge. But those challenges will take a long way to get through the courts, as Nick says. Nick's right that on the issue of posturing, Nick's right that Republicans in Congress may be posturing when they're saying that, we'll deal with this. Don't worry, Supreme Court. We've got this. You go ahead and do the right thing. But it's also possible that defenders of the government are posturing when they are trying to play up the dislocation that would follow a ruling for the plaintiffs, and so because they want to frighten the court and tell so that the court will not rule for the plaintiffs and put an end to those illegal subsidies. And so there's been some who've wondered if the people who are now saying there is no way for the states to do anything about this, and no way for the executive branch of the federal government to do anything after a post-King ruling, will suddenly discover some sort of fix that the administration can put in place after a ruling for the plaintiffs. I don't know. We'll have to see if that's the case.
Okay, I think we're going to try to go to the phones now. Operator, can you remind everyone how they can ask a question over the phone?
If you would like to ask a question, please press star, then the number 1 on your telephone keypad.
Do we have questions lined up?
Your first question comes from Doug Pennington. Your line is now open.
Hi, thank you. This is Doug Pennington. I'm from Constitutional Accountability Center. I had a question for Mr. Cannon. I was just listening to the exchange you had with Julie a little bit earlier, and it reminded me that you've already once had to retract a claim that you made about now former Senator Baucus and what he believed about the availability of tax credits on federal exchanges. You did that last summer on your Forbes.com page. You made claims in your current King brief, or at least intimations, about what Senator Ben Nelson intended around tax credits, and as you know, he himself has flatly contradicted any such intimation in a letter that is cited in CAC's brief to the court. And now you have Ms. Rovner, the moderator of today's webinar, flatly contradicting what you claim her story says in your brief. And I know that for some reason you take your interpretation of her own work over hers, but I wonder if, with some reflection, you will decide that actually you should probably formally withdraw that citation in your brief in some communication to the U.S. Supreme Court. Will you do that?
Well, I want to thank one of my most persistent critics from the Constitutional Accountability Center for joining this webinar and asking the first question, and note that yes, I did retract the claim that we made about Max Baucus. Not because I think that my interpretation was incorrect, but because I couldn't prove that it was the correct one. And I did it after someone said to me, "Wait, you have to look at it from this perspective as well." I considered that perspective. I realized that person was right, and I corrected my error. You forgot we also had another error in our briefs having to do with a bill introduced by Dick Durbin. We claimed it did something that it did not do, and I issued a retraction there. And if you can convince me that Julie's interpretation of her own story is not contradicted by her own story, then I'll be happy to make the change that you suggest. But no one has been able to do that, not even Julie herself, because both the docket letter and her story can only be interpreted in one way, and that is that that Congressman Doggett and his colleagues who co-signed that letter to Nancy Pelosi and Barack Obama warning about the exchange provisions of the PPACA clearly precluded the potential of residents of the state receiving any benefit from those exchange provisions if the state refused to establish the exchange itself, even if a federal fallback exchange were established in its place. So make the case, and I'll be happy to make that retraction if it's persuasive.
I mean, the first thing I would do would be to refer back to what Professor Bagley said, and anybody who's listening in and watching this webinar today should really read the Doggett letter and then read pages 28 to 29 of your and Professor Adler's brief and figure out how in heaven's name those two things track with each other. And then read Ms. Rovner's piece in full context. Again, Professor Bagley and Ms. Rovner herself, pointed pieces of this out and think how in heaven's name that piece from 2010 from Julie could possibly support in any way the assertion that you make. They just simply do not. And I think maybe on some reflection, you yourself will agree with that. And if you do, that you will take the action that I suggested.
So the question is, when am I finally going to agree with you? And my answer is when you finally make a persuasive case. I encourage everyone to reread the Doggett letter, Julie's article, and my brief with Jonathan Adler before the Supreme Court. But I think it's also important to recognize that while I think we're right on that issue, on the interpretation of that letter, this is a side show. What Congress, even if there were no legislative history supporting the plain meaning of the text, and even if the legislative history contradicted the plain meaning of the text, the plain meaning of the text is that these subsidies are available only, quote, through an exchange established by the state, and that prevails. If it's clear, which it is, then that is the law.
Okay. Operator, can we have our next question, please?
Your next question comes from Catherine Morris. Your line is now open. And Catherine Morris, your line is now open.
Thank you. I emailed this question earlier, so it may not be as eloquent, but my concern is I asked if anyone anticipated that the IRS would be able to implement the penalty or the tax, whatever you want to call it, this year, effective with my 215 filing. In other words, do you anticipate that they'll be taking 2% of the income of those who haven't signed up? And if so, do you anticipate new lawsuits stemming from that action?
Nick, why don't you take it? Let's take the answer.
Okay.
If I'm understanding the question correctly, here's how the individual mandate thing works. If you, with tax credits, would spend less than 8% of your income purchasing a health plan, paying the premiums toward a health plan on the exchange, then you're subject to the mandate. And if you choose not to buy insurance, you're going to have to pay some penalty to the federal government. When Michael talks about relieving people of the individual mandate, what he means is that if you wipe out the tax credits, many, many more people are going to exceed the 8% threshold. So it's going to cost more than 8% of their income to buy a health plan. So when he talks about relieving people of the individual mandate, what he means is that lots of people who'd be unable to afford a health plan anyway will no longer be required to under the law. That's not a great deal in my book, but that's what he's referring to. So no, the individual mandate, if you would be unable to afford a health plan in the second half of in the second half of 2015, if you'd be unable to afford a health plan without the tax credits, you would not be subject to the individual mandate.
Michael, is that your understanding too?
It is.
Okay.
It doesn't actually answer my question, though. I have no intention whatsoever of signing up for the ACA. So what I want to know is, what do you anticipate how will I be penalized for making that choice? How and when?
Yeah, it would depend on your income.
It depends on your household size.
It has nothing to do with my income, though.
Well, actually, the penalty might have something to do with your income. It depends on your household size, your income, and the cost of the lowest cost bronze plan on the exchange in your state. And I can't remember what the minimum penalty is for 2015 for singles or families, but I think it is a flat dollar amount or 2% of income, whichever is greater, up to the amount of that premium.
The 2015 minimum penalty is $325, but I think what she's asking, if I get this correctly, is what happens if the Supreme Court rules that the subsidies go away. Is that right, questioner?
No, I was just wondering if, since this is taking quite a while for it to get through the court, if people like me who are not signing up for it will see the IRS take the 2% or $325 or whatever it's going to be as soon as this tax season. That's my question.
Well, if you did not purchase health insurance in 2014 and you're not eligible for any of the exemptions from the individual mandate for 2014, then the IRS will be levying a penalty against you, and you are expected to pay that. There are ways to avoid paying it, but the way this case would affect you is, as Nick said, if they had not offered you those subsidies, and by not offering you, if you had been, if in 2014 you were eligible for, if in 2014 the administration offered you a tax credit for which you were not eligible, and by offering you that tax credit, they lowered the amount that you would have to pay for a bronze plan premium from above 8% of your income to below 8% of your income, then you would have been unlawfully penalized, and you should be able to get back the money that you paid to the IRS. I'm sorry to make that so complicated, but that's the law.
Okay. Okay. We're going to leave that there for now. Can we go on to our next question, operator?
Your next question comes from Joe Tassi. Your line is now open.
Oh, hi. Appreciate the discussion. And I'm going to try to sneak two questions into one here. The first is really a big picture relating to the Supreme Court process and how much they would really, how much do they really consider consequences versus just looking at the interpretation of the law. So that's kind of maybe the question part of it. But I'm really thinking of the Section 1321 that you noted. That seems to me, says maybe the guy on the street, that if the state fails to establish an exchange, the HHS shall establish and operate an exchange. This seems to have been the set up default option, and that citizens would then be able to benefit from premium support, which is kind of an underpinning of the whole law, in addition to the improvements, the clinical improvements with the triple aim and so forth. So, that's just kind of a big picture from your discussion. It seems like that's the default option set up, and what are they really going to decide? But second part of the question really gets to, how, from your expertise, how much will consequences be weighted versus letter of law?
Yeah, I'll start. Sorry, Julie, I missed that.
Oh, go ahead. You start.
Great. In terms of consequences, I think two things are true. The court is going to focus primarily on the text of the statute, try to figure out its meaning. The second thing that's true is that the court is attentive to the consequences of its decisions. And part of the reason for that is the more outlandish or bizarre a series of consequences are, sometimes that can tell you something about what Congress meant. So it'll play a role. How big a role is very difficult to say. On the sort of view that the man on the street would see this as sort of this is clearly a fallback option, that tax credits are an indispensable part of all this, that it'd be very strange to have a fallback healthcare.gov exchange. that was dysfunctional and that didn't actually work. I think all of that's true. And in fact, the Affordable Care Act is a scheme of cooperative federalism. And by that, I mean it's very similar to a lot of other statutes that we already have on the books. The Clean Air Act, for example, is the nation's preeminent air pollution law. And it says, here are some national standards. And those national standards are standards that we insist upon across the whole country, but we'll let states take the lead role in figuring out how to achieve those air quality standards within the states. Now, if the states don't wish to, the federal government will come in as a backstop, and will take care of it on behalf of the states. And that's exactly the scheme that Congress created here in the Affordable Care Act. And the notion that it was, in fact, a different sort of regime, one that threatens drastic and dire consequences for the states if they didn't sign up. Again, the statute just does not support that interpretation.
Michael?
Except that the statute, as is clear to a man on the street, only authorizes tax credits, quote, through an exchange established by the state. It's the only text in the statute that speaks directly to the question of whether tax credits are available through a federally established exchange, and it flatly says no. That's obvious to any man on the street. And as for Nick's claim that, why would, or the man on the street's concern, that why would Congress create a federal fallback that wouldn't work, there is, well, first of all, again, the bill passed by the Health, Education, Labor, and Pensions Committee would have done the same thing, and not only a federal fallback that wouldn't work, but state-run exchanges wouldn't work either, and the government concedes that these Senate Democrats voted for a bill that would have done just that. What Nick is saying is unreasonable, created an exchange program that would not work. But the premise underlying this point is one that Nick doesn't actually vocalize because it's really silly. It would sound really silly if he were to vocalize it, which is that Congress would never pass a law that doesn't work. Congress passes laws that don't work all the time. Congress passed provisions, there are provisions of the PPACA that didn't work, and one of them is the Class Act. The Class Act was a long-term care entitlement program, the third big entitlement program that Congress created in the PPACA, and there were warnings from Medicare's own chief actuary. The government's own top actuary said that this program will collapse in an adverse selection death spiral. Why? Because you've got community-rated premiums for this program, which creates the potential for adverse selection, and you've got nothing to mitigate that adverse selection. Either you're not forcing people to buy this health insurance through a mandate, you're not subsidizing it because there's an explicit prohibition on subsidies to the Class Act, and so the actuary said it's going to fail. Congress passed it anyway. So really what a large part of Nick's argument here is that, well, gosh, if the plaintiffs are right and the plain meaning of the statute is what Congress intended, then Congress passed a bill that would fail, and I don't want this bill to fail, so please rewrite the statute.
With respect to Michael, that's not my position, but I'll let it go.
All right, I think we have time for a couple more calls. Operator, are there more calls on the line?
Your last question from over the phone is from James Stevens. Your line is now open.
Good afternoon. This is James Stevens from Georgia, and we're one of the states who did not set up a state exchange. I have two questions. One is, was the architects and administration of the ACA, weren't they really thinking all 50 states would participate in the exchange, in the exchanges, and were caught off guard a little bit about how many did not come in with state exchanges?
Yes.
Yeah.
They expected all states to establish an exchange, as Nick had admitted, and even in a very telling part of the government's brief before the Supreme Court is the government makes the case that everyone expected some states to refuse to establish exchanges. Now, that's pure revisionism because that didn't even become a feasible possibility until November of 2010, several months after this law was passed, when Republicans shellacked Democrats in the November elections and took over a lot of state legislative chambers and governorships. And in the government's brief, when they try to make this case the evidence they draw upon are claims by random Republican members of Congress who are trying to create the impression that, well, the states won't implement this law, when no one believes them. I didn't believe them when I heard them saying it at the time. What's most telling is that the government doesn't cite any authors or supporters of the PPACA as saying that states will not implement this law, because they all believe that it would. And that is not just Michael Cannon and the Cato Institute saying that. Nick Bagley agrees. The New York Times has written about this. The administration, even after the law was passed, was saying that states are very eager to do this, and they were taken by surprise when they realized that 15, 30, or more states would refuse to establish exchanges.
Just to make a tweak, a technical correction to Michael's statement about my views, it is true that the expectation was that the states would be happy to set up exchanges, because exchanges are a non-controversial idea. They're basically a way to organize the insurance market. They're pro-competitive. They're a good idea. And people at the time thought that states would be happy to keep the federal government out of their state insurance markets. They thought that the states would be, even if they didn't like the Affordable Care Act, that they'd rather do it instead of having the federal government do it. But Congress also understood that some states might not wish to establish exchanges. And how do we know that? Because Congress included a federal fallback. They understood that not all states might wish to do so. And the reason that they had the federal fallback is to make sure that the states that failed to do so could not thwart the objective of the Act, which was to extend near universal insurance coverage across the entire country. Nobody during the debates thought that this would be a selectively applicable law, with people in Georgia getting tax credits and insurance coverage, and people in California getting tax credits and insurance coverage, but people in Georgia losing out. Nobody wanted that.
Well, on that subject, there's another question that someone sent in advance. We talked a little bit about what Congress might do if the Supreme Court rules with the challengers. What might the states do if the Supreme Court goes with the challengers? Obviously, particularly the states that have not already set up their own exchanges. Michael, you want to go first?
Well, Nick has written pretty extensively on this. He says that it's going to be very hard for states to establish exchanges and downright impossible to avoid, even if they want to, downright impossible to do it so quickly that they avoid any disruption. And so, but the states will probably be crafting other responses other than establishing exchanges, things that they could get off the ground sooner. They will probably look for ways to provide some sort of relief for the real victims of the administration's attempt to rewrite the law. These are the people with high-cost conditions who are in federal exchanges right now, who would lose the subsidies and maybe lose their coverage. There are things that states can do to subsidize them. It could be a separate high-risk pool. It could be just giving them cash so that they can help, so that they can pay their premiums. And there are some interesting ways that states could fund that. But as far as, so there are ways to provide relief to these folks without establishing an exchange, and they might cost states less than establishing an exchange.
If they were to cost the states less than establishing an exchange, they probably wouldn't be nearly as effective, because of course it would be purely state money without any help from the federal government. The important point is that the states are going to have a very difficult time responding nimbly to any kind of decision from the court. They will come under intense pressure to establish exchanges, but a lot of these states will resist that pressure, just as we've seen a lot of states resist pressure to expand their Medicaid programs. And there are serious technical, legal, and challenges to establishing exchanges at the state level. So, would you expect a couple of states to flip? Maybe, and maybe fairly soon. Would you expect all of them to, or even a large majority of them to? Probably not. At least in the medium term, the consequences of an adverse ruling here are difficult to overstate.
And last question here, this also comes from something that someone asked in advance. We keep hearing from the administration that they don't have any contingency plans in case the ruling goes against them. And we also know that the money to create exchanges basically ended last year. Is there any way that the administration could come up with some money to perhaps help some of the states in the event they might want to try to create an exchange? Michael?
Well, the administration has requested such funds in their budget submission, which I think is an admission that they don't have the funds that they want in order to do that. But I think an important point to recognize is the administration has not said that it does not have a contingency plan. The administration has refused to answer the question, and it's really irresponsible, I think unconscionable, to refuse to answer that question for a couple of reasons. One of them is that people in the exchanges are facing a very serious risk that they will lose their subsidies, face a large tax liability, see their premium bills quadruple, and maybe even lose their health plans. And the administration is not warning them about this risk, not informing them about this risk, as they demand that insurers inform enrollees of all material features of the plan or risks underneath the plan. In fact, they're hiding that information from enrollees because they want to enroll as many of them as possible. They want to expose as many of them as possible to these risks. Now, you can think there are two reasons for this, a few reasons. One, they just want their efforts to be a success. But two, they are hoping that they can, they're hiding that information from people so they can enroll more people in healthcare.gov, because that would increase the disruption of a ruling for the plaintiffs and possibly prejudice the courts against the plaintiffs for that reason. And even if the courts still rule for the plaintiffs, they figure that that is a population that they can mobilize to lobby Congress to reinstate those subsidies. And the problem is that they are misleading people and using people as pawns by trying to by hiding this information from them and trying to use them for their political purposes.
Nick?
You know, whether HHS could scrape under the couch cushions to find money for the exchanges, I'm not sure. I think it would be easier if they had an appropriation dedicated to that, but they don't anymore. So it's a hard question. On the broader point about what the administration ought to or ought not to be saying, I just say it's a little bit unusual for Michael to, have pushed this litigation so hard, litigation that he, as he now acknowledges, could potentially harm a great many people, and then accuse the administration on the other side of the table of playing fast and loose. I think that's a little rich. The point here is that there are real lives at stake. There are real consequences from an adverse governmental decision here. Could HHS potentially pick up some of the pieces? It's possible, but it's very hard to see how. Could the states potentially do so? Sure, but the obstacles are much, much bigger than people appreciate. Could Congress do so? Very doubtful. Again, it is difficult to overstate just how big a deal this case would be if the government loses it.
I'd like to respond to something that Nick just said there. Jonathan Adler and I blew the whistle on this, the government's reinterpretation of the law and its plan to issue illegal subsidies and impose illegal taxes in states with federal exchanges almost 4 years ago now, 3.5 years ago now. We tried to get this resolved before it would cause any dislocation whatsoever. The government's position was to delay that litigation for as long as possible because it wanted to get to January of 2014. It wanted to get that money out the door. It wanted to get that money into people's hands so that they would lobby their members of Congress. And Kathleen Sebelius, the former Secretary of Health and Human Services, who helped effect this revision of the law, was very explicit about that. She said that they are trying to get to 2014 because when you get that money in people's hands, they will work with their members of Congress to protect it. So it is not the case. So I take exception to what Nick said about it being rich, that I am trying to stand up for the people that the administration is exposing to these risks. I did not create these risks. Jonathan Adler did not. The attorneys in King v. Burwell did not. The administration created these risks when it decided to depart from the plain meaning of the words through an exchange established by the state. It heightened these risks when it delayed the litigation so that it would not be resolved before 2014. And it continues to heighten those risks by trying to enroll more and more people in healthcare.gov without informing them of the risks that that coverage presents. It is unconscionable what this administration has done.
All right, well, I think that's going to have to be the last word because we are already over time. I want to apologize to everybody who did not get their questions asked. We were sort of inundated with questions, but I'm sure that these gentlemen will do this again probably several more times before the Supreme Court hears the case in March, and then probably several more times before we hear from the Supreme Court about what it decides. So thank you very much, and I'm going to turn it back to Catherine.
Thank you. Thanks, Julie, Nicholas, and Michael for taking time from your busy schedules and joining us today.